All right. Welcome to the Critical Perspectives on Justice and Inequality speaker series hosted by the Center for Criminology and Sociolegal Studies at the University of Toronto. I'm delighted to welcome Professor Michele Goodwin to speak with us today, and we'll also be hearing from Olivia Berkowitz, a student here at the Center for Criminology and Sociolegal Studies. Before we begin, I'd like to acknowledge the sacred land on which the Center for Criminology and Sociolegal Studies operates. It has been a site of human activity for 15,000 years. This land is the territory of the Huron-Wendat and Petun First Nations, the Seneca, and most recently the Mississaugas of the Credit River. The territory was the subject of the Dish with One Spoon Wampum Belt Covenant, an agreement between the Iroquois Confederacy and Confederacy of the Ojibwe and allied nations to peaceably share and care for the resources around the Great Lakes. Today, the meeting place of Toronto is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work in the community on this territory. I'd now like to introduce Professor Michele Goodwin, who's the Chancellor's Professor at the University of California, Irvine, and founding director of the Center for Biotechnology and Global Health Policy. She's the recipient of the 2021 Distinguished Senior Faculty Award for Research, the highest honor bestowed by the University of California, and the first law professor at the University of California, Irvine to receive this award. She's an elected member of the American Law Institute, as well as an elected fellow of the American Bar Foundation and the Hastings Center. She is an American Legal Institute advisor for the Restatement Third of Torts Remedies. She has published very widely in the fields of constitutional and health law, among other areas. Her work has addressed such diverse legal questions as freedom of speech, religious exercise, equal protection, due process, race and sex discrimination, reproductive rights, slavery, and LGBTQ equality. She ranks among the most cited professors in the field of health law, a field which she has helped to shape and establish. Trained in sociology and anthropology, Professor Goodwin has conducted field research in Asia, Africa, Europe, and North America. Her books include Policing the Womb, Invisible Women and the Criminalization of Motherhood, which we're delighted that she'll be speaking about to us today, and also Biotechnology, Bioethics, and the Law in 2015, Baby Markets, Mummy and the Politics of Creating Families in 2010, and Black Markets, the Supply and Demand of Body Parts in 2006. So we are absolutely thrilled to host you today, Professor Goodwin. And before I turn it over to you, I'll just briefly set up our format for this afternoon. Professor Goodwin will offer her remarks, which will then be followed by a brief comment by Olivia Berkowitz, and then we'll open up the conversation to the group. And we'll be concluding today's event slightly earlier at 2:45 because Professor Goodwin has to run to a class, so she's very generously squeezing us into a busy law school faculty schedule. So without further ado, please take it away, Professor Goodwin.
Thank you so very much for that very generous introduction. And I'll apologize to those in the internet world if the connection is a little bit spotty. We regret that. It's a pleasure to be with you all, our northern friends and cousins. I'm zooming in from California. And it's a pleasure to be speaking with you about this book, Policing the Womb, Invisible Women and the Criminalization of Motherhood. It is a book that originally I thought would take 2 years to write, and it was a 10-year project. The more that I delved in the various areas that one could unpack as part of a bundle of liberties or rights or expectations, the more that one could find, easily stumble across, or sometimes dig a bit to find ways in which who can become pregnant, women were being denied the promises that came from Roe v. Wade and Planned Parenthood v. Casey. But even more importantly, seeing various other infractions in terms of constitutional rights that implicated the First Amendment, Eighth Amendment, 14th Amendment, basic freedoms and equalities, privacy, autonomy, bodily autonomy, civil liberties, and civil rights. Coming across cases, for example, of women being threatened with arrest for refusing C-section, women being civilly incarcerated because they disclosed having a prior medical dependency on prescription medications, the use of laws to prohibit pregnant persons at end of life from being able to make their own decisions with regard to their bodies. um, individuals arrested for things like falling down steps while pregnant. These made up a broad sphere of concerns that extended beyond abortion that really weren't being taken up in mainstream media. And there was also the need to look back, further back, at the ways in which the state and also private actors conspired around the bodies of women to limit their reproductive autonomy and ultimately impose threatening conditions on their reproductive health. And so perhaps one of the better ways for me to begin this talk and to center it a little bit is to give some indication about the journey in this space as being something that is more than just the modern. One can look at the kind of policing the womb and the stories that are told in this book as being about contemporary challenges. After all, between 2010 and 2013, there were more anti-abortion laws that were proposed and enacted in the United States than the 30 years prior. That happening primarily at the state level. And so that is a stunning and startling story. It's a story that results from targeted regulations against abortion providers, what are known as trap laws, taking hold and fastening within the legislative space. So that's a story that could be told. But if we broaden the lens and we were to look at who were the people that were most affected by this, what we could easily come to after very little study is to see that it was mostly poor women who were implicated by, and many of them poor women of color. And that is to say that for people of better means, they're able to do as they did even during a time in which abortion was criminalized, and that is go elsewhere to support their pregnancy terminations. It also meant whatever kind of care that those individuals needed during their pregnancy, they could go to their private providers who are far less likely to snitch on them, as one of my colleagues in the field says. And that is to say that seeing their private providers or private providers when being told that these individuals may have struggled at a prior time with prescription addiction or anything else would not have found it logical to call police and disclose confidential patient information, but instead would just seek to treat their patient. So that is the story for people who have better means, but there's a longer story for people who have lesser means, and that would include considering the United States period of eugenics, fastened by the 1927 decision in Buck v. Bell, where the United States Supreme Court took up a challenge to a Virginia model law providing for compulsory sterilization. It was the time in which our United States Supreme Court said that 3 generations of imbeciles were enough. The case involved Carrie Buck, who at 16 years old had been raped and gave birth to her rapist, to the child resulting from that rape. And the state of Virginia had enacted a model law that provided for the forced sterilization of individuals that the state saw as being unfit morally, socially, who knows, whatever else, physically. And the Supreme Court upheld the law. In fact, for pandemic purposes, you all might find this interesting that the court said that the authority that the state had to compel inoculation was broad enough to cover cutting the fallopian tubes. That's the language from the court. The court said better than to let the offspring starve for their imbecility or become criminals, society can prevent those who are manifestly unfit from continuing their kind. And so while policing the womb could have looked at these modern trap laws, these kind of modern iterations, it dove back to understand the platforms, the ecosystems that could allow for these contemporary times. And in reality, we could dive back even further, a time in which we think about indigenous people being free in their lands and then the kidnap, trafficking, and enslavement of Africans brought to the United States as a kind of testing point, an early point for policing the womb. After all, it's Sojourner Truth. The name may be familiar. You may say, well, isn't that the person who uttered, Ain't I a Woman, about this speech from the 1850s as being one that is about chivalry. And the truth of it is, she does talk about chivalry and no one opens up a door for a Black woman. But what's interesting in the more than 150 years since that speech was originally given is that Madam Sojourner Truth also said, and I bore 13 children and nearly each one snatched from my arms, and nobody heard my cry but God, ain't I a woman? And in many ways, that's really the starting point of thinking about policing the womb. Now, what does it mean in contemporary context? Well, the book takes us on a journey, and as part of this journey, it addresses these matters of abortion, creeping criminalization, revisiting the fiduciary relationship between medical providers and their patients, creating criminals of women by race, stereotype, and the collateral damage that occurs because of that. It talks about the pregnancy penalty. What happens when the state gets it wrong? When the state is so enamored and so committed to fetal protection, but it actually miscalculates. And then the book also has lessons for law, a reproductive justice or New Deal or Bill of Rights that should come forward. And there is an epilogue that involves President Trump and others. Why don't I take on just the two things that I want to do? I want to read a little bit from the book to you, but I also want to set the stage in terms of the kinds of concerns that are illuminated in the book. In part, what began for me with this book was seeing the ways in which state lawmakers and also non-lawmakers, prosecutors, use discretion in policing, surveilling, arresting, and prosecuting poor women for miscarriages and also for stillbirths. The justifications were that these women had acknowledged to a medical provider that they had used an illicit drug during their pregnancy. And then, as a part two to that, there was a concern that babies were being born low birth weight. But it was an interesting tale of two cities in many ways for me, because at the time in which these prosecutions were taking place and the uptick was also the time in which one became far more aware of in vitro fertilization, assisted reproductive technology, the crowding of the womb with the multiple gestations. One image was decidedly Black and brown, those who were being arrested for birthing, for stillbirth, or birthing children who were low birth weight connected with having used a drug during their pregnancies. On the other hand, what was happening was that there were babies that were being born in extreme low birth weight through multiple gestations. And very often, those infants were dying. Millions of dollars were spent in order to help protect and keep alive those babies if they would survive. And there was no narrative link between the two conversations that were really necessary. On one hand, Black and brown women were being condemned for the drugs that they took and the outcomes of their those births. On the other hand, there were white families that were being lauded and celebrated, and websites devoted to them, and funds being sent to them, and even visits to the White House, even when there were babies that were born with extreme low birth weight or even dying after birth. How could one reconcile these two very different worlds? And how could one reconcile a third prong, and that third prong being empirical data tracking in the United States the use of prescription medications during pregnancy? And it turned out that according to race, white women, income, wealthier white women, education, educated, wealthier white women, a trajectory of the use of prescription medications, pretty heavy prescription medications during pregnancy, and not just one, but Oxycontin and other kinds of heavy medications being used, Demerol, in cocktail formation, and again, not the kind of policing that one could see of Black and brown women. And so what the book does is it takes one on a journey in which one sees some of these cases, like Regina Mcknight, the first woman in the United States to be prosecuted for a stillbirth. She was 23 years old, had been a farm worker. Her mother had died. She was despondent. She confided in her medical providers that she had used an illicit drug during her pregnancy, and that was what was used to justify the punishment that was inflicted on her. A 20-year plea deal reduced down to 12 years, or the case of Rainey Gibbs, a 15-year-old Black girl from Mississippi who was charged with depraved heart murder for her stillbirth, in a case where she too had confided to medical providers that she had used an illicit drug during her pregnancy, or the case of Lisa Epstein, which then marked a little bit of a shift, a white woman in Florida who had been threatened by her doctor to come in on that day and be subjected to a C-section, and her failure to do so was his threat that he would have police come to her home and drag her out of her home into the hospital. All Lisa Epstein had wanted was 2 additional days in order to see if she could come into labor naturally. The distinction between the case of Lisa Epstein or that of Regina Mcknight, or Rainey Gibbs, is that Lisa Epstein was better off. White woman, middle class. She called her attorney, and the hospital backed down right away, and the doctor in question issued an apology. But these cases are not one-offs. That is to say, while it could sound episodic, it could sound anecdotal, they're not. I spent time in Alabama on the ground, meeting with prosecutors, talking with prosecutors. In Alabama, there is a fetal endangerment law. It is actually a child endangerment law, which has been applied as a fetal endangerment law. But this child endangerment law was originally enacted to have nothing to do with pregnant women. It was a law to actually squelch or to temper down the turning of homes into meth labs. What the state knew is that largely the people who were dealing in meth were white men in Alabama. And these men were converting their homes or using their homes to create meth laboratories. But what was interesting is that that's not the population that was being policed under this child endangerment statute. The population being policed under the statute happened to be pregnant women, and more of them poor pregnant white women. So much so that in just the last recent years, over 500 poor, mostly poor white women have been arrested for endangering their fetuses under the guise of this particular law. So these are matters in the extreme, but matters that may not get much public attention. And so, why have I turned to a variety of these areas and not just simply abortion? Well, it's very interesting that when we think about reproductive rights, so much of that has been gleaned through a lens of thinking only about abortion and abortion access. If you were to compare that with a narrative of civil rights, there are some pretty glaring distinctions. Within the case of civil rights, we understand it to be broader than just simply access to education. Within the context of the United States, it was Brown v. Board of Education, which was the turning point in US jurisprudence, move away from separate but equal. And so the case was foundational. But what was understood by the lawyers who worked in that area, ultimately jurisprudence of the Supreme Court, was education the only obstacle where race and Jim Crow politics had undermined the civil liberties and the civil rights of African Americans. It was also understood that employment, access to accommodations, housing, and other areas were also implicated by civil rights. And if we're to think about reproductive rights, my argument is that we need to be as broad and expansive there too. These are not just matters of abortion. It's matters of being able to be dignified in one's own body, whether it is to choose to terminate a pregnancy, to carry a pregnancy to term, to have access to birth control, to have access to education, such as sex education, the right to be free from state surveillance and criminalization. And so what the book seeks to do is to unpack across a broader spectrum and lens in these particular spaces. And so that's what the book does. And what I'd like to do is to turn to the introduction of the book. And if you'll forgive me, I'd like to read a little bit of this to you. All right. This is not a work of fiction, although I wish it were. Some of the cases described here could recall the imagery evoked in Mary Shelley's Frankenstein. In that book, she tells a horror story about a young rogue scientist who creates an unsightly monster through clandestine, aberrant experimentation. Although Frankenstein is the name of the monster's creator, Dr. Victor Frankenstein, readers would be forgiven for debating who the real monster happens to be. In Policing the Womb, the story of Marlise Munoz comes to mind. Brain dead, decomposing in a Texas hospital, forced by state legislation to gestate a barely developing fetus while her body decays and the anomalies in the fetus mount. Eventually, it is reported that the fetus is hydrocephalic. This means that it's developing fluid on its brain, and that it also means that this will result in severe brain damage. Medical reports also show that the fetus is not developing in its lower extremities. The state knows that brain death is irreversible. The hospital forces Marlise's body to shake, placing it on a bed that constantly and violently moves, which makes the dead woman's eyes flap open and shut. Likely, this opening and shutting of Marlise's eyes frightened some hospital staff, and so they decide to tape Marlise's eyes shut. Even if Marlise could see anything, which is unlikely because she is dead, no one now needs to look into her eyes to search for any signs of life. If the state believes, despite well-accepted medical science, that she is alive, it has now taken away her sight and forced her into a state of blindness while her body is poked and prodded. Marlise's shaking corpse stays hydrated through fluids and tubes that are put into her body. Somehow the hospital finds a way to pipe away the waste. Everyone, including even the state, agrees that she really is an incubator. This is why the Texas law exists. This is not the novel The Handmaid's Tale, a dystopian opus written by Margaret Atwood, a wonderful Canadian, made exceedingly relevant today. The shaking bed is not in the totalitarian fictional state of Gilead. No, this is Texas. This is why the state forces machines to be attached to Marlise's body to keep her organs functioning until they give out. The machines are not keeping her alive. They are simply keeping her organs viable. This is why the hospital cleaves into her body with slicing, lacerating, and stitching tools. This is why it tapes her eyes shut and why it pumps her with fluid and then drains her body of the liquids that remain of her. Her decaying has nothing to do with senescence or aging. Rather, it is the typical decomposition characteristic of brain dead cases. Hoses, pipes, and cylinders serve as the conduits between the state and Marlise's decaying body. This is known as mechanical support. I'm going to skip just a little bit. No one except perhaps a select group of anti-abortion protesters outside is confused about her brain death. Outside, someone tells filmmaker Rebecca Hamowitz, just give it a week. You'll see, he says. A week or two will turn all of this around, he says. This particular protester who's captured in Hamowitz's film is like a professional at this, she said. These are the kinds of circumstances on which he shows up. But what's interesting about the backdrop of this idea that somehow she'll wake up, it reminds me of the film Sleeping Beauty. This being the fairy tale that as soon as the prince comes, he will kiss the maiden in distress and she will come awake. But what's interesting here is that the state had dethroned Marlise's husband, Eric. He had no rights to his wife's body. So who was the prince? Was it the state of Texas? Ultimately, in this case, a judge decided that life support could be removed from Marlise's body. The court did not make an adjudication with regard to the validity of or the constitutionality of the law. The court seemed moved by the fact that the fetus was abnormally developing. What's clear in these cases is that the hospital serves as a surrogate or an agent of the state. This is not a role that its staff have asked for, but some fear the consequences if they do not follow the state's legislation. In this case, the medical staff know that Marlise is dead, but they must follow the Texas law, which ignores death, do not resuscitate orders, medical directives, and living wills, but only if the patient is pregnant. Thank you.
Thank you so much, Professor Goodwin, for that powerful and succinct summary of what is an incredibly complex and rich piece of scholarship. So I 100% encourage all of everyone watching to read the whole book. It's just a small taste, but it really encapsulates the spirit. So thank you so much. Next, I'm just going to invite Olivia Berkowitz, who's a first-year PhD student at the center, to offer a few remarks and to start us on a brief discussion. Olivia is interested in the social impact of reproductive technologies, the history of reproductive medicine, and the current legal and medical regulation of the pregnant body. So she is a perfect respondent for Professor Goodwin today. So Olivia, I'll turn it over to you.
Thank you, Professor Evans. And thank you very much, Professor Goodwin, for your fascinating presentation today. I found your book both captivating and generative. I was overcome with ideas and questions and emotions while reading, and hearing you speak today confirms both the importance and the urgency of your project. I'll be keeping my comments today brief, but I would like to propose a few points of discussion and questions for reflection before we move on to the Q&A period. Firstly, I was interested in your call to reimagine the reproductive rights framework. Today, public and political discourse focuses largely on the life and personhood of the fetus and on abortion. But as you and other scholars like Dorothy Roberts have suggested, this narrow framing of reproductive justice ignores myriad legal infringements on women's liberty, autonomy, and privacy. While reading, I wondered, how does the visibility of the abortion debate and the relative invisibility of other regulations on the female body further naturalize the division between woman and fetus and reify the construction of the fetus as an independent, autonomous rights bearer? Many US states now recognize the fetus as a legal person, some jurisdictions even claiming that embryos and pre-embryos rights are comparable to the pregnant woman's. The animation of the fetus in legal and public imaginaries has played out in devastating ways, as you describe in the book. I'm reminded here of your retelling of the story of Angela Carter, who at 27 years old was a cancer survivor in remission and pregnant for the first time. In her second trimester, doctors found a tumor in her lung, and so she sought the appropriate medical treatment, radiation and chemotherapy. But rather than pursue this course of action, her doctors petitioned the courts to provide an emergency C-section to protect her growing fetus. Despite Angela's protests, the operation was performed. Tragically, both Angela and her 26-week-old fetus died shortly after the surgery. While reflecting on this chilling story, I thought about how the state uses the personification of the fetus to justify the seizure of the pregnant body as public property. I wondered whether the Carter case demonstrates how women's rights as citizens are made contingent. Her citizenship is qualified or revoked to serve the higher interest of the fetus. Indeed, I remember the scholar Cynthia Daniels, who asks, does the ability to carry a fetus to term necessarily change women's relationship to the state and alter women's standing as citizens in the liberal polity? Notably though, not all pregnant bodies are treated in this way. In Policing the Womb, you connect the current legal and medical regulation of pregnant women to historic and ongoing legacies of racial oppression. For centuries, enslavers claimed ownership in women's reproductive capacities, their bodies, and labor. And though today one cannot legally control another's reproductive choices, the state, under the guise of fetal protection, certainly can. Evidently, control over the reproductive process has not ended, just shifted, transmuting the control over Black bodies and reproduction into a politically palatable form. In your book, you explore the new and old laws that are being applied to police maternal conduct and how these laws are most often applied to women of color. I wonder, how are these laws both informed by and consequently reproducing racist assumptions about Black mothers? And further, how do we begin to dismantle the state and public project? This question is broad and ambitious, but I wonder if one way to start is by elevating the narratives of women and shedding light on their stories. This was one thing that I was particularly caught by in your book. By recounting their experiences in great detail, we come to know who Diana Sanchez, Rainey Gibbs, Regina Mcknight, and Marlise Munoz are, and why their stories matter not just to women, but to everyone. Indeed, the book's focus is not solely on the fetus or on the termination of a pregnancy, but on the many ways that legal and medical actors intervene in the reproductive process and the consequences that has on the lives of women and their families. Importantly, you describe the blurring of medical and legal systems, whereby medical actors are endowed with policing powers, called on to interpret state law and to act as hospital snitches. While reading this, I thought about the historical entanglements of law and medicine. You illustrate, for example, how the criminalization of abortion in the late 19th century was connected to campaigns launched by male physicians in an effort to professionalize gynecology. This movement was both anti-abortion and anti-midwife, apologies, an effort to usurp control of pregnancy from the lay women who administered care. Certainly, I think that exploring these historical connections help us understand the current fusion of these institutions and why we continue to seek legal remedies for health matters. I'll conclude my remarks here by shifting gears slightly and asking what is perhaps a more situated question. How might these American laws, preceded by a history of racial oppression and the modern legal personhood of the fetus, seep into other jurisdictions? How might it play out in the Canadian context? In Canada, embryos and fetuses do not gain legal status or rights until they are born alive, and the Supreme Court has determined that the woman and fetus are physically one person under the law. But there's also a history of state intervention into women's bodies that continues today. In fact, Indigenous women report accounts of coerced sterilizations as recently as 2018, and Indigenous children are significantly overrepresented in the child welfare system. Reproductive conduct is, in many ways, regulated. So might Canadian settler law be creeping towards the American example, and how do we resist it? I've proposed a number of questions here, surely all of which cannot be addressed, but I do hope that this spurs some thoughts or questions as we contemplate the policing of the womb. Thank you.
Thank you so much, Olivia. And Professor Goodwin, I'll just leave it to you if you'd like to take a moment to respond to some or all of Olivia's remarks, or if not, I'm very happy to sift some questions from our very active chat. So I'll leave it with you.
So the first thing that I want to do is to acknowledge how impressed and honored I am by Olivia's reflections on this book. Olivia, please send me your comments. They're great. I really appreciate them. They're terrific. You know, I wonder about what, there are two ways of thinking about the last issue that you posed, what could creep north. And then there's also another way of flipping it, what we can learn from where you all are, right? So is this an opportunity to learn from Canada and to say that there are distinctions here? And really, when you think about how the United States applies these fetal protection laws, it applies them only against pregnant women, right? So no other space does a fetus or an embryo have this kind of standing that the court that state legislatures are interpreting it to have, and that depending upon the state, the courts might too. I mean, otherwise it doesn't exist. You don't have an embryo can't contract for a car. An embryo can't register for school. An embryo can't purchase a house. There are any number of areas of law where, of course, an embryo has absolutely no standing and no relevance. Within the context of our Constitution, there is not fetal personhood at all. These are machinations that were politically inscribed, and that political inscription I talk about within the context of the book. So anyway, I think that the issues that you raise are really terrific, and they are a number of them in capacity, thinking about matters of forced coercive sterilization, how that has impacted the lives of women of color in Canada, Indigenous women, even as recently as 2018. We have some of that narrative in the United States with allegations coming from our detention centers that coercive sterilizations have taken place just within recent months. So these are issues that have much to do with how we situate whose bodies matter and whose bodies do not. And then also the ability of those people to be able to curate a response from the populace, right? So if we think about a period of eugenics, or we think about contemporary challenges facing Indigenous women or detainees, what's the state's value of bodies? What's the society's value of these persons and bodies? And so to the extent that you say that you found value in the elevation of people's stories and their names, that was exactly what I sought to do, which was to humanize the people who've been most affected by these state turns towards the criminalization and the imposition against women and their bodies. I'd love to spend more time with your commentary. I do hope that you'll share it with me. I find it to be incredibly impressive, and I hope that it will be published because it's worthy of a broader audience engagement.
That's fabulous. And I absolutely share Professor Goodwin's enthusiasm. So let's get that dissertation written, Olivia. There's so much brilliance to share. So I'll just pose one or two questions from our chat. It's so active. And apparently our wonderful administrator, Kate, is going to send you the transcript of the chat, Professor, after this is all over. So any questions that weren't answered during the session will still be on record. So I have a question from Audrey Macklin, who is the chair of our department, who's currently on leave. And she asks, she was struck by the link between poor and racialized women seeking medical assistance through the public healthcare system and police and penal intervention. Outside the United States, there is more or less universal public healthcare. So would you be able to perhaps say more about the nexus between a healthcare system organized around private healthcare provision, where public healthcare becomes a vehicle for disciplining poor and racialized people, and criminalizing pregnancy of those same women?
Well, it's a great question. So it speaks to the organization of U.S. healthcare. The United States doesn't have universal healthcare, and there's a backdrop of surveillance and criminalization of poor people. The sort of surveilling of poor people in public spaces is a kind of consistent theme within the United States, alongside of failure to recognize poverty as a status or a class status for which then there could be any kind of constitutional rights associated with one status as an impoverished person. And one sees the great links or extents to which the dangers of targeting and surveilling poor people can go, such as eugenics in the United States. I mean, there was a period of time in which US legislators and others were saying that the Nazis in Germany were beating them at their own game, because the law that was adopted in Germany for eugenics practice was actually based on the US model law, which is something that a lot of Americans don't know, but that just happens to be the case. And then the silence about it, I think, reflects the shame of what we understand is happening. It happened in Nazi Germany. And so your question with regard to these public spaces as being ripe for policing also has its aegis in our historic formations. The original police in the United States were slave patrol police. And their responsibility was, in fact, to engage in the kind of public space of policing Black people, and in fact, also in private spaces. So their role was to patrol what would they called highways, which could just simply be roads. Who are these people on the roads? Can you show us your passes? But they also had the authority to go into the cabins as well, right? So I think part of it is the public space, but I think another part of it is an understanding that certain people don't even get the private space. So that it is public and then also the private of the policing of people who've been vulnerable in societies where racism has played a significant role, such as in the United States.
And what spaces could be more private and yet claimed so publicly than the womb?
Absolutely.
Yeah, I think we have time for one more brief question, and then we'll conclude. The question comes from Mumi Asubiaro, who's a PhD student in our department, and she wonders if you might be able to speak to the religious underpinnings of laws like this and the way that presumably a Judeo-Christian framework is informing these kinds of laws.
So that's a very interesting question too, because one certainly sees the kind of lean in justifying or upholding these kinds of laws, or even in the promulgation of them, right? The kind of lean into religion. But, one also has to wonder, to what extent is religion being used as a proxy for carrying out another kind of power agenda, right? So if you looked at the history, at least in terms of how this unfolded in the United States, the sort of first wave of anti-abortion sort of like crackdown is to understand that nearly 100% of women's reproductive health care up until around the time of the Civil War was all done by women, lay midwives. And it's at this time in which there's kind of a perfect storm, which is that there's the medicalization, the professionalization of gynecology and obstetrics. Who's doing this? But, white men who are experimenting on enslaved women, and they're creating tools of gynecology, I mean, literal tools of gynecology that are forming from their experimentation. And these people are looking to make their way in this space. And how do you make your way in this space when it's dominant 100% women control? Up until this time, there is no legislating and laws that are anti-abortion, anti-contraception, anti any of that. And these men are also articulating in their pamphlets, which they're calling books, interestingly, about a lot of male insecurity, right? They're talking about how the other doctors don't respect them, how these doctors are saying that they're just doing women's work, right? And so then there's a need to create another kind of scapegoat. Who becomes the scapegoat but midwives themselves? And it's horrific and chilling to read the ways in which they talk about midwives, that they're dirty, that they're unsanitary, things that are just absolute lies. And then they wield authority of the American Medical Association to give themselves a platform for articulating these issues. What they're really interested in is a monopoly. And they're interested in a monopoly that they're able to control. And in fact, they do, right? Medical schools bar women from admission. So these people who had been midwives can't now suddenly become doctors, even though they have this kind of learned backdrop and knowledge in this space. The AMA becomes a tool for articulating bans on midwifery or licensure standards for midwifery. And in addition, they begin another platform, which is this anti-abortion platform, right? They didn't have to use religion at that time, but what was interesting, because this harnesses around the time of the Civil War, is that they use race. And so they write about the urgent need for white women to use their loins and spread their loins and go north and south and west, right? This kind of fear of after slavery being overpopulated by Black people, right? There are twists and turns in the narratives of who gets to control women's body and who gets to make profit off of women's bodies. And today, religion becomes a source of it. And to the questioner's point, what is very interesting is a very narrow slice of fundamentalism and Catholicism being used and deployed in this space. This isn't like writ large religion, because there are religious faiths that don't recognize personhood until after birth. So it's a very important question. It's a question that is fraught and rich for further discussion, which I do in other aspects of my work. Let me just say, it's been a pleasure to be with you all, a real joy. I look forward to the next time I'm actually able to be physically present in Toronto. So I hope that I will get a future invitation where I can actually come, be in person, and we can talk through these issues, because they're not going away, sadly.
Thank you so much, Professor Goodwin. Fraught and complex doesn't even begin to describe it. But yes, we would be absolutely beyond delighted to host you in person for a protracted conversation and set of conversations around these issues. So thank you so, so much. We're very grateful to have been able to speak with you this afternoon.
Thank you so much. Until soon.
Until soon.